Started now.
Thank you. We'll get started. Great. Well, good morning and welcome. My name is Cathy Grason and I serve as the Maryland Insurance Commissioner. This is our third public hearing relating to the administration's implementation of Section 15-144 of the insurance article. That section, as amended in 2020, requires carriers to submit reports analyzing their compliance with the Federal Mental Health Parity and Addiction Equity Act. The Maryland Insurance Administration is required to develop standard forms for these reports and regulations to implement the law by December 31st, 2021. Our first two meetings focused on the scope of the reports. We are here this morning to receive comments on the initial draft of the regulation and reporting forms prepared by the administration as part of our implementation of 15-144. Those drafts were posted to the administration's website and we received several written comments. Following this hearing, we will continue to accept comments through September 7th. As we get started, let me first introduce the MIA staff who are here this morning. Corey Boone, my Chief of Staff.
Good morning.
David Cooney, our Associate Commissioner for Life and Health.
Good morning.
Erica Bailey, our Associate Commissioner for Market Regulation and Professional Licensing. Mary Quay, the Chief for Life and Health Complaints.
Good morning.
Lisa Larson, the Director of Hearings and Regulations.
Hey, everybody.
Lisa Hall, our Deputy Counsel from the Office of the Attorney General.
Good morning.
And Craig I, our Director of Communications.
Good morning.
Please note that this hearing is a public hearing that is being held via the Zoom webinar platform and is being recorded. The video and sound recording will be made available on the MIA's website within the next few days. In addition to the administration staff, only individuals who signed up to speak and who have accessed this meeting through the link that they were sent will be able to be seen and heard. If you fall into that category but have not been able to log in, please let us know via the chat feature and Craig will make you a panelist. If you did not sign up to speak but you wish to be heard, please let us know also via the chat function. As time and technology allow, we will offer a chance for unregistered attendees to speak. And to ensure the excellent sound quality throughout the hearing, we ask that you please stay on mute unless you're speaking. I just want to take a minute to sort of contextualize today's discussion. In developing the regulations, templates, and instructions that were posted, the MIA team considered the requirements of Maryland law, comments made in earlier public meetings, and reviewed similar reporting requirements in other states. Subsequent to the passage of Maryland's law, the Federal Consolidated Appropriations Act made an analysis similar to that required by the reports mandatory at the federal level starting on February 10th, 2021. The MIA reviewed the sub-regulatory guidance issued by the federal government and also the reporting requirements in other states, including Pennsylvania, Texas, Colorado, and Washington. The regulations set forth general requirements for the reports. The templates and instructions provide more detailed information and direction. The instructions and definitions were written to ensure that carriers are consistent in their analysis. In some cases, terms may have different definitions for purposes of the analysis than they may have in the general usage concerning health insurance. Uncodified language in the bill required the MIA to use the NAIC's data collection tool for mental health parity analysis of non-quantitative treatment limitations, what we call NQTLs, and any amendments by the commissioner to the tool necessary to incorporate the requirements of 15-144 C, D, and E of the insurance article. The templates posted by the MIA use the NAIC data collection tool, although we did move to a Word format for ease of use. The NAIC data collection tool lists 13 categories of NQTLs. At a prior public hearing, we discussed adding reimbursement rates as an additional NQTL, and we have in fact done that. We have heard concerns that the administration. We okay, Craig? Is there a problem, Craig?
We're okay.
Okay. We have heard concerns that the administration should require additional NQTLs to be included in the mandatory reports. Our goal is to be able to conduct a meaningful, in-depth review of each report, and to do so, we are targeting the NQTLs that have been identified by the NAIC and the Department of Labor as most important. That does not mean that the administration is not enforcing federal or state law. The reports required by 15144 are an analytical tool that is useful to us and useful to the legislature. They are not, however, the source of the administration's investigative or enforcement authority. The administration enforces the law through complaint and market conduct procedures. If we receive information that leads us to believe that we should examine these or additional NQTLs with respect to a particular plan, we have the authority to do so at any time. We do not require a report to investigate the conduct of our licensees. Further, data within the templates will enable us to identify circumstances in which the administration needs to perform additional investigation as to specific plans. For example, network adequacy is not listed as a separate NQTL on the draft reporting form, but the category standards for provider credentialing and contracting and the required data to verify in-operation standards for prior authorization will give us information necessary to determine whether additional inquiry into network adequacy is needed. The reporting forms that we are developing under 15144 are an important tool and an important basis of analysis and information, but they are neither the beginning nor the end of the work that we do or our authority in this area. The administration has also posted additional templates to provide data that will allow us to verify assertions made in the analysis for specific NQTLs, that the NQTL is applied no more stringently with respect to mental health and substance use disorder benefits than to medical surgical benefits. While disparities in data are not dispositive evidence of a violation, disparities may point to areas where further analysis is needed. David, I wanted to give you the opportunity, if you'd like to speak more specifically to the templates and review them before we hear from our speakers.
Sure. Thank you, Commissioner. I'm still going to provide a pretty high-level overview, but I'm going to go into a little more detail on some of these items, and particularly the regulations, the templates, and the instructions that were posted to our website. And as speakers speak later on, if there's any specific questions, I'm happy to go into greater detail. But first, looking at the regulations, what we're trying to do here, we're defining the most important terms that are used in the statute, the regulations themselves, or in the template forms and instructions. And then also we're establishing the regulatory standard for the NQTL analysis report, the data report, the summary form, and the compliance plan that carriers are required to submit if our review of the reports reveals non-compliance with any NQTL requirements. Generally, the regulations just refer to the website and indicate that carriers must use the template forms and instructions that will be posted to the MIA website. But one of the more substantive provisions in the regulation is that we provide very specific standards for what must be included in a report in order for the MIA to determine it's a complete report. And this is important because the statute expressly authorizes the MIA to impose penalties if we receive incomplete reports from carriers. So as we're looking at this, we pulled, as we did with all the information that we'll discuss today, we pulled from various regulatory sources. And when we were looking at what constitutes a complete report, we particularly looked at the Department of Labor self-compliance tool and the Department of Labor FAQ 45, which was released in April of this year. We also looked at other states and in particular Texas for this section here. The other most substantive item from the regulations I'd like to highlight is the definition section. We did receive some public comments questioning why we define certain terms, mentioning that some of these terms were either already defined elsewhere in the insurance article, or they're commonly used terms where they're understood by their plain meaning. And for this, it's very important to also note that the statute specifically directed the MIA to adopt regulations to ensure uniform definitions. And if we don't actually define them, we can't be sure that all companies are in fact using these terms consistently. And also, as the commissioner mentioned, it's just important to note that even if this is a term that has a common general meaning or is defined specifically elsewhere in the insurance article, The definitions we have here are specifically in the context of these reports, and any comments made on the definitions should keep that in mind. For the definitions, we looked at other regulatory sources, and particularly sources that had defined these terms in the context of MAPIA analysis. And we pulled heavily from Maryland Medicaid, from Texas, Washington, Colorado, from the Department of Labor self-compliance tool. And in situations where there was a term we needed to use based on the statute that there wasn't an existing commonly used definition in the MAPIA context, we came up with our own internally developed definition to basically define the term in the context of what exactly we'll need for these reports. Turning to the actual template forms themselves, first I'll just speak briefly on the main data report form. This is a very straightforward and self-explanatory form in our view. The statute identified very specific data elements that we needed to request in this context. In the form, we basically just put that in an Excel format to make it easy to sort through and report. And there's not really much to that, but again, be happy to answer if there's any questions later. The NQTL analysis report template, on the other hand, that's the more complicated form, and that is where the statute directed us to start with the NAIC tool and only make revisions that would be necessary to address the requirements of the law. And that's exactly what we did. We started with the NAIC tool, and then we looked through subsection C, D, and E of the new statute. And there's a lot of information in there that frankly is just not contemplated by the NAIC tool. So we had to supplement it and add things there. And then again, we just changed the format slightly to make it the chart easier for carriers to input the information and then for MIA staff to review it once it comes in. But the most important thing for ensuring that the initial reports we receive from carriers include all the information that the MIA needs to determine compliance is the instructions for completing those forms. The instructions we posted, they follow the specific steps outlined in 15.144 of the insurance article. And they include a description of everything we've determined we'll need in order to make our final determination of compliance. The instructions are not intended to be onerous. This is just information. If it's not included initially in the reports, we would have to ask for it anyway in order to complete our review. We want our expectations to the industry to be very clear up front. And to be frank, in the past, what we've received from carriers in response to general requests for NQTL compliance, whether it's in the context of complaint investigations, market conduct actions, or form review, it has been grossly insufficient until we've gone ahead and had to ask very specific follow-up questions. And that's led to a lot of back and forth correspondence, has really delayed the whole process of determining whether or not there has been a violation. So the goal here is to cut down on that as much as possible and just make it very clear to the carriers exactly the level of detail we need up front in order to complete our analysis. We strive not to impose any unreasonable data request or any kind of completely new requirements. And again, we really just pulled from existing regulatory requirements in the federal level and other states. With specifically, again, the DOL self-compliance tool, a lot of it you'll see really aligns very closely with that. DOL FAQ 45, the federal regulations themselves, the same states we've mentioned previously, Texas, Colorado, Washington, Pennsylvania. And then we also consulted the 6-step parity compliance guide from the Kennedy Forum. We basically just took the most clear guidance we could find from those sources, looked where Maryland law, what the legislature had specifically put in 15.144 might have differed in any extent and modified it as needed in that context, and just tried to make the instructions as clear as possible so that we can get the information we need. Finally, the last item I'd like to talk about is those data supplements that the commissioner mentioned earlier. So these are 4 supplements to the NQTL analysis report for the purpose of verifying the in-operation portion of the comparative analysis for some of the specific NQTL categories that are on the NAIC tool. As we've mentioned, these will not in and of themselves show compliance or violations, but they may either identify red flags for possible in-operation violations or lend support for a carrier's assertions that there is compliance. So essentially, we have to ensure that once the carriers have applied all their written policies and procedures related to the NQTL, these data supplements is just an additional check to see when they've actually applied them in practice, whether or not we're seeing disparate results or we're seeing results that support that, in fact, these are comparable. And those 4 supplements here, the first is for utilization review. And that's tied specifically to the NQTL categories on the tool for prior authorization, concurrent review, retrospective review, and pharmacy services. The second data supplement is for formulary exceptions, and that ties to the category of prescription drug formulary design. And then the last two are provider credentialing and reimbursement rates, which obviously are tied to the categories that have the same name. We also posted associated instructions for each of the supplements to make it clear how carriers are supposed to complete those items. And that really is my summary of what we posted. Again, I'd be happy to go into more detail if there's questions later, but at this time, I'll turn it back over to the commissioner to introduce our first registered speaker.
Thank you. I appreciate that, David. Before we get started, just briefly, I don't know whether Erica or Mary or anybody else on the MIA had any additional comments they wish to make. Okay, all right, thank you. Before we get started, I just want to take a second to thank this team. Under Erica's leadership and David's leadership, Mary and Teresa Morphy, who's not with us this morning, you have done a terrific job in putting together an enormous amount of effort and work to bring these regulations to bear. Lisa Larson, who drafted them for us with the help from Lisa Hall from the Attorney General's office. This was really a very large, significant team endeavor. And I want to personally thank you for all the time and the effort that you have all put into it over these last months. So with that, let us now introduce our first registered speaker. One of the things I want to ask really for all of the speakers today is our topic today is the content of the regulations and the reporting forms. And I would ask you to the extent possible to please focus and limit your comments to that topic. When you're called upon, I'm just going to ask you to unmute your line, provide your full name and any affiliation you may have. And we're going to go in order in which people signed up. And first we'll hear from Ellen Weber, the Vice President of Health Initiatives for the Legal Action Center. Ellen, lovely to see you this morning and happy to hear from you. Thanks for joining us.
Thank you so much, Commissioner Bergan, and thanks to everybody at the MIA who clearly worked incredibly hard to pull these materials together, to pull the regulations together, to review sort of a vast amount of information that is out there and now available, and we do appreciate those efforts. I am Ellen Weber. I'm with the Legal Action Center, and the Legal Action Center also convenes the Maryland Parity Coalition that has again worked on these issues for many, many years. We have submitted comments on the draft rule. I'm happy to answer any questions that you have about that. And we will be providing additional comments on the forms themselves by that September 7th deadline. What I'd like to identify briefly are sort of three overarching comments. The first, and again, I know in your opening remarks, Commissioner Bergan, you've already sort of addressed some of this in some ways, but I do have, again, some additional reflections on that. So if, with your indulgence, I would like to address some of those issues. So first, there are key NQTLs that are not subject to the reporting requirement based on the templates. We want to talk a little bit about that. The second issue is the regulations and the report templates appear to conflate the NQT analysis for mental health and substance use disorder benefits as opposed to requiring a separate analysis and reporting of mental health benefit compliance and substance use disorder compliance with the Parity Act. This clearly violates the federal and state law, and we'll just briefly touch on that. And then third, we again do appreciate the additional requirement to report on reimbursement. As you can tell from our comments, we do have some concerns about the definitions related to this NQTL. And in further now looking at the template, we do have some concerns about that reimbursement template. Courtney Bergan is on this call and will be presenting comments and remarks about that reimbursement template specifically. So going back quickly to the first point, missing NQTLs. Again, as we all know, in December 2020, Congress amended the Parity Act to require issuers and health plans to conduct annual parity compliance analyses on all NQTLs, to document those analyses, and upon request, to submit them to federal or state regulators. the MIA's use of the NAIC template without some additional further revisions, just in our view, creates a lower compliance standard than federal law, and it therefore violates federal law. Under our state law, section 15144 C1(2) requires carriers to demonstrate compliance with the Parity Act, not just 15144 alone. And so requiring compliance analysis on anything less than all NQTLs violates the Federal Parity Act and its reporting provisions, and thus state law because it incorporates the Parity Act. Now, we realize that the MIA has broader enforcement authority than just these reports, that you can conduct analyses, you can do market conduct requests, but the key point of what this law has done, what 15144 does, is it actually requires reporting to consumers about compliance by carriers. And if carriers are not required to analyze all NQTLs and report out that compliance through the summary form, then consumers are not getting a full understanding of whether the health plan that they purchased complies with federal law. They have no sense of all of the various enforcement actions that go on behind the scenes, many of which are not reported out because they are public until there are findings issued. It's this law that has now been put into place, and the federal law, that gives consumers an understanding of whether their plan violates federal law or not. It's for that reason that while we obviously, with great respect, understand that the MIA will conduct other types of investigations, the failure to have a full analysis of all NQTLs and available to consumers, in our view, does violate federal law. Again, there are several NQTLs, some of which you've already identified, that I just want to highlight very quickly. Network adequacy. We all understand that that is a key issue. And the problem that we have with—
I'm sorry, Ellen, could I just interrupt and ask you, who are you saying is violating federal law?
We believe that the MIA, without expanding the NAIC form to include all NQTLs, violates federal law. And again, we'll refer back just to the most recent Texas template, and Texas has now just implemented and finalized that rule. The NQTL form, that report form that Texas uses, does not follow the NAIC form. What it does is it is an open-ended form that requires carriers to list all NQTLs that are applied in all of the 6 classifications, and then to conduct an analysis on each of those. So it doesn't presume what the carriers are using, but it requires complete NQTL analysis. If you look at Maryland Medicaid has required the use of the URAC Parity Manager tool. That Parity Manager tool, similarly, it is an open-ended request for all NQTLs. It in no way limits them as the NAIC form did. And I think the source of our problem is that the NAIC form was never intended to be a parity compliance tool. It was a market conduct tool. And even more important, it has never been updated now to comply with the 2020 Consolidated Budget Act agreement. So it was developed without any federal reporting requirements. It's now being used for a purpose for which it was never intended. And it was never updated to address the changes under federal law. We obviously didn't agree with its utilization during the legislative process, but that said, now that we have a federal standard that says you have to report, the carriers have to conduct a compliance analysis on all NQTLs, and it gives consumers an expectation that that's going to be done, this tool is no longer adequate. And for that purpose, we believe that this standard was preempted by federal law.
Okay, so Ellen, I'm gonna appreciate your legal analysis. We will respectfully disagree with that legal analysis, as we have done in the past. We obviously work very closely with our, attorneys general. And so we will respectfully agree to disagree on that point. I would very much like to hear your substantive comments as they relate to the templates, however.
Great.
So, we can have additional conversation offline with regard to sort of the jurisdictional preemption legal issues. We think that the statutory language and the uncodified language is clear. We think the intent of the legislature is clear. We do not believe that the state is in violation of federal law, and we believe we're implementing precisely what the General Assembly asked us to do. But again, I respect your point of view. But for today's purposes, it would be extremely helpful to hear what you think about, the templates that do exist. That would be very valuable to us.
Sure, be happy to do that. And again, we will be providing additional
Sure.
written comments because obviously it's just,
It's a lot.
it's a lot. There's a ton here, but I want to give you the highlights. So first, let me talk about the scope of services, okay? The scope of services issue, the MIA's draft proposed definition of scope of services is very complete. And it's very complete in part because what it does is it correctly identifies that the exclusion of a specific or type of mental health or substance use disorder treatment is part of that definition. The NQTL form, however, item 12, which covers, the scope of the limits on duration of scope of services, doesn't implement that definition. Instead, what it does is it lists questions that focus on restrictions on geographic locations and types of facilities. Those are certainly included, but those should not be the exclusive responses that the carriers provide. And so those limited questions create confusion on our part as to the intended breadth of responses, again, because it's inconsistent with the definition. And I believe it will create incomplete and potentially inconsistent responses from the carriers themselves. So that's one problem. Now, this same problem, the fact that there are specific questions that were again embedded from that NAIC tool that are included in many of the NQTL items, those specific questions, again, in our view, in many situations, are just far more limiting than they're allowed to be. And so in our written comments, we will identify each one of those. But that scope of services is the most vivid one for these purposes. There are other certain template issues that, again, we think are not consistent with the Parity Act standards. One, and these are certain situations in which the template, again, this is because of the NIC template. This is not because of what the MIA has done. It's because the NIC template itself is wrong. What that template does, for example, is it identifies emergency services as an NQTL. This is NQTL number 5. When in fact, emergency services is a classification. It's one of the 6 classifications. Now, it's also in your templates included as a classification. It can't be both unless you give a great deal more explanation as what you intend to be reported out with regard to emergency services. The same problem exists for pharmacy services, which is NQTL 6 on the form, and prescription drug formulary design, which is NQTL 7. Those are, again, they're both identified as NQTLs, but prescription drugs is a classification. And so from our mind, it's really unclear as to how, it can't be both an NQTL and a classification. And if it's an NQTL, we don't know how emergency care, prescription drug formulary, or pharmacy services apply in the other 4 classifications. And so that's why the form is very confusing. So that's that problem. And again, we think this derives from the NAIC form itself. It's just not intended for this purpose. So that's sort of the overarching comments with regard to that template. And if you have specific questions, I'm happy to answer them. As I said, we're happy to provide some additional information. The second point, though, is really, I'm sorry.
I was going to say, unless my team does, I think that given sort of the granular nature of this discussion, it probably, Ellen, makes more sense for us to receive your detailed comments. And, we can always circle back if we have questions after we receive them.
That's great. Be happy to answer them. This next point, again, a far shorter explanation here. There is a conflating on these forms, with the exception of one of those forms, a conflating of the reporting of the mental health and substance use disorder analysis. That just violates federal law. Those are separate analyses. You have to show that the mental health benefits comply with the Parity Act. They're comparable and no more stringent to medical surgical, and and the carriers have to show that the substance use disorder benefits are similarly. In our comments, we've identified both the federal regulatory standards and the state statutory standards that create that separate comparative analysis requirement. And there's good reason for that. And the good reason for that is that the carriers impose different NQTLs on mental health benefits and substance use disorder benefits. And a satisfaction on the mental health side doesn't mean there's satisfaction on the substance use side, or vice versa. The Maryland Insurance Administration recognized this point. In the market conduct surveys that you conducted from 2015 to 2020, your analyses identified NQTLs that were applied to mental health benefits and not substance use disorder benefits, and you identified NQTLs that were applied to substance use disorder benefits that weren't applied to mental health benefits. Carriers impose different standards, and they have to comply with the law with regard to both. So as we noted in our comments, we urge you to remove that combined MH/SUD definition, and in its place, just remove that, and remove that in any place in that where you have in the draft regulations, and substitute for that mental health and substance use disorder, and make clear on the templates, as you did already on one of them, that this is a separate analysis and the reporting must be separate. There are obviously tools that can be used with drop downs on your template that will make it easier to identify whether this applies to mental health or substance use disorder. The bottom line is not only the operation also varies by mental health and substance use disorder benefits. And so that's another reason that analysis must be discrete. So that is, again, one of the key concerns that underlies all of our comments here, and it will either make or break the utility of all of this work and all of the reporting that the carriers are going to do. Happy to answer any questions on that. And just to point out with one template with a sort of a vivid example of this, and this is the formulary exception form, right? What that does is it requires the gathering of very important information. But again, there are many more mental health medications for mental health conditions than there are for substance use disorders. And if you conflate that, we will lose valuable information, for example, about what limitations exist for medications that are treating opioid use disorders. And this is at the height of the worst opioid epidemic our state has ever seen. There are medications that are incredibly effective to treat opioid use disorders, and we want to know whether there are restrictions in access to that. Without separating out the mental health from the substance use disorder, we will never know whether there are restrictions on greater restrictions on substance use disorder medications than exist in the medical surgical field. So that again is just one more concrete example. And then finally, I won't go on in detail with regard to the reimbursement rate forms, but I guess we support and truly appreciate the MIA including reimbursement rate setting. But there is some inconsistency in the definitions with the NQTL template itself. And as we noted in our comments, the definition of reimbursement is a quite expansive definition. We've identified a few additional things that we think need to be added, again, in part to reflect what the federal regulations say about identifying out-of-network usual and customary rates. And in our view, the rate setting process for single case agreements. But the more problematic definition for us is reimbursement rates. We don't understand, I guess, two parts. We don't understand why there's a different definition between reimbursement and reimbursement rate. And we don't understand why reimbursement rate seems to be limited to value-based and other alternative reimbursement formulations. We think that reimbursement rate incorporates not only what you have in reimbursement, but it also includes what you have in reimbursement rate. But then the more complicated factor is in the template itself. You've asked for reimbursement rate setting, the reimbursement rate setting, what the process is for the reimbursement rate setting. That is the proper analysis that is needed, but there's no definition of reimbursement rate setting. There's a definition for reimbursement and there's a definition for reimbursement rate. So we think all of that needs to be coordinated and aligned and again clarified so that carriers are reporting out all of their NQTLs with regard to reimbursement rate setting. So that's the issue with regard to that part of the NQTL form. And as I mentioned, our comments will provide additional detail on your actual, the reimbursement rate data template, which gets to that operational point, which again, we appreciate you seeking additional data to look at that. We do think that there's some concerns. We do have some concerns. And again, Courtney is going to identify a number of those. So again, thank you for letting me take so much time to set this out. We are very, very excited about this opportunity and very encouraged by the effort to really develop a very strong set of regulations. And we are particularly appreciative of the incorporation of some of that NQTL 45 information about what constitutes the complete report. Because again, we all know that, that a lot of time and energy is going to be put into completing these reports. Your office is going to invest a lot of time and we want them to be as effective as possible.
Great, thank you, Ellen. We always appreciate your comments. David, Erica, Mary, Lisa, do you have any questions for Ellen? All right, well, thank you, Ellen, very much. We appreciate it. I don't know if there's anyone from the MIA that wants to make any comments themselves before we move on. Okay, not seeing anything. I will move us to our next speaker, who is Matt Celentano, the Executive Director of the League of Life and Health Insurers of Maryland. Matt?
Commissioner Bergan, thank you very much for the opportunity. I had some remarks sort of prepared, but in light of Ms. Weber's comments, I think I'll just let our written comments suffice to be crystal clear and not to get into sort of the discussion of the MIA's authority. The only thing that I will say is that some of the supplemental data forms we think, or we believe, go a little farther than the DOL supplements. And the federal landscape has certainly changed dramatically, I would argue, and we're still getting guidance. And having a divergent approach has the impact of being harmful. We're also concerned about the operational challenge of having the other 49 states for some of the carriers that operate outside of Maryland. So like I said, we will be submitting comments in the coming weeks. And thank you for the opportunity. And we are always available to help if we can.
Thank you, Matt. We appreciate that. We do understand, that there is a certain amount of questions that folks have about what the federal government is going to do and what the continued guidance is going to be. But nonetheless, we cannot wait for the federal government to issue regulations. We have a directive from our legislature and a set of expectations from our legislature. And so we have an obligation and responsibility to move forward as best we can. So we'll look forward to hearing your specific comments in writing. And thanks for being here today.
Thank you.
The next person who signed up was Kimberly Robinson, the Regional Director for State Government Relations for Cigna. Kim?
Sorry, having a little delay coming off of mute. Good morning, Commissioner Bergan. I'm actually going to go ahead and just defer to Matt's comments. The only thing I will echo with Matt, and I appreciate your response, Commissioner Bergan, in regards to waiting for the federal government. Certainly understand the need for Maryland to be able to move forward. I think we'll have a good conversation about how we balance staying in alignment with what's available from the federal government. I think the concern is not so much waiting for the feds, although it is helpful because what we're talking about is in fact federal law, where ultimately what they determine their law says is going to be what's most important, being that it is in fact the federal law, but trying to make sure that we're working to find that right balance so that we are not creating incredible challenges operationally and disruption for carriers who are trying to balance what we're reporting in the other 50 states, as well as what's happening in the federal law. And so I think there's a way to do that. And so we'll continue to work with Matt in providing those comments to you.
Thanks, Kim. I was having trouble finding mine as well. We appreciate that. Our next panel is from Care First. We have Deb Ripken, Darcy Smith, Cathy Grason. Cathy, understand that you'll take the lead and that Ms. Ripken and Ms. Smith are there in case we have additional questions.
Yes, that's correct. Thank you so much, Commissioner Bergan, and thanks for the opportunity to speak today. So I'm not going to get super granular. We are absolutely going to give you a granular letter and point out any particular concerns that we have. Rest assured, we really are working with the breadth of operational colleagues that would have to pull the breadth of data and making sure we can stand it up, seeing if there's maybe a better way to do it, a different way to do it, or whether it works great the way it is. So that's the type of comment we hope to provide you. But at a very high level, just to frame up, for Care First, the parity reporting has never been about, our concerns have never been about the MIA's authority. We've maintained that you have very broad authority to ask us virtually anytime you want about, the various data points and questions in these reports. Our contention has just been whether a comprehensive report that's going to require a tremendous amount of resources on our part and on your part is necessitated on an annual basis, or whether that information is better drawn on an ad hoc basis as needed, in your opinion, as our regulator. So folks will recall that, prior to last year's bill, we had come off several years of very in-depth market conduct work on this. Our position when the bill was deliberated in 2020 was that the NAIC template was the best way to streamline what the legislature felt was important to be submitted on an annual basis. But as others have flagged with the Consolidated Appropriations Act since coming out, some of what's required may have deviated from what was pondered in the legislation. So what we're really trying to do effectively is evaluate what the Consolidated Appropriations Act and the current federal statutes require, because as you noted, we don't have the regs yet, versus what the Maryland law requires. With respect to anything outside those parameters, really just evaluating whether that's something that is a good use of resources on an annual basis. Is there anything that's in excess of what's required? So that's what we hope to get to you. We share what Kim kind of flagged is we have 3 jurisdictions. I know a lot of our competitors have 51. Just how we can streamline whatever the end product looks like vis-a-vis, what we'll be doing in other states that makes the data, frankly, more valuable, I think, to regulators as a whole to be able to look at how things stand up nationally. So we welcome any specific questions you guys have from us, as always. But that's where we are. We're really just trying to filter through what the feds require, how this regulation and forms line up with what Maryland's going to require you to do, regardless of what the feds do. And we hope to have that to you we will have that to you by the 7th. Thank you.
Thank you. Much appreciated. Anything from the MIA for any of the carriers?
No, Commissioner, thank you.
Thanks. So we will next turn to Laura Mitchell, a substance abuse prevention advocate. Laura, it's always a pleasure to see you. I haven't seen you yet. Are you on?
Commissioner, she is not on. She said she may join later.
Okay, all right. Well, let me know if you don't mind monitoring Craig to see if she jumps on.
Sure will.
And Courtney Bergan, Ms. Bergan is a primary senator for the University of Maryland Student Government Association and a JD candidate. Ms. Bergan, also a pleasure to see you again today. Not sure that we can hear you.
Yeah.
I think you show as being off mute, but we're not.
What
we're
about
not
now?
here.
Can you hear
There
me
you
better now?
go.
Yes, that's good.
Okay.
Very good. Welcome.
So, thank you for all of the work you guys put into preparing these data collection forms. As Ms. Weber mentioned, my comments are primarily on the reimbursement form, pretty specifically. So first, I noticed that there are just 3 service codes being collected. My concern about that is that just a very small segment of the mental health and substance use disorder services billed through commercial insurers. So we're going to be collecting just very minimal data through that. It's not giving us a holistic perspective of what's happening in terms of reimbursement. Second, neither nurse practitioners, physician assistants, nor LCPCs were included on these forms. I think that's a pretty important thing to include because there are a significant portion of the providers on commercial insurer panels, especially with the growing shift to NPs as prescribers. And while Medicare reimbursement does not include LCPCs, I think it would be reasonable to use the reimbursement rate for social workers since they're both master's level clinicians. So I don't think it would be unreasonable to include them in an analysis. Then third, just reliance on Medicare rates in general, I think needs to be done with caution because as we all know, Medicare is not subject to parity compliance. So some of the base rates may already be disparate when doing relative reimbursement analyses. Then fourth, getting to more granular things, I noticed that the MIA is using the national payment amount rather than a local MAC or a locality that Medicare bills. And I think that's really important, specifically when it comes to the Maryland markets, because Maryland reimbursement rates through Medicare MACs, local MACs, range from anywhere from about 114% of the national payment amount to 102%. So there's pretty big disparities, but especially within the Baltimore and DC suburbs, those rates are significantly more, but even all of the Maryland rates are greater than the national payment amount. So I think it might be important to evaluate using one of the local MACs as a base rather than the national payment amount. And then when looking at the forms specifically, the rates that were used on those forms were actually the 2020 rates rather than the 2021 rates. So just to note that I think it's important to update those since the 2021 rates are pretty significantly different from those used. And then finally, I think when looking at the facility versus non-facility based claims, I think it's important to take into account Table A specifically asks insurers to put in and use non-facility based claims. Tables B1 and B2 were a little bit less clear about that. However, my concerns about the facility versus non-facility based claims is that medical providers are have a lot more of an ability to bill facility fees, which then reduces their practice expenses, et cetera. Whereas most mental health providers don't even have the ability to bill a facility-based fee for outpatient visits. So if that's not being distinguished and weighted in this analysis, that could just throw off any analysis in terms of assessing parity compliance. And then the last one is just another pretty specific comment on the instructions. It just asks insurers to submit data from January 1, 2021 through the latest month in 2020. I believe that was intended to say 2021, so I just wanted to point that out as some small thing. But other than that, I just think it's important that overall we just gather information on more codes and more providers and use the local payment amounts, as I think that would be pretty important to giving an accurate analysis of what's happening on the market.
Thank you, Ms. Bergan, for your remarks. And you are, along with Ms. Weber, going to be submitting, all of these very specific details.
Yes, I will be submitting those with her, so
Excellent.
those will be included.
No, I appreciate that. And I thank you for pointing those things out for us today. Is there anyone from my team that wants to address any of the issues that Ms. Bergan raised? Okay, well, thank you again. We will look forward to receiving your additional comments, and we will circle back as necessary with any follow-up questions we have once we're able to walk through that detail. And I see that Ms. Mitchell has joined us. So what I'll do is give her the opportunity to jump in. If Ms. Mitchell, you have any comments that you want to make on the content of the regulation or the specifics of the templates, we'd be happy to hear from you.
I'm sorry, I'm still driving at this time. I wanted to listen, but I'm not able to comment.
That's okay. Please be safe while you're driving. And if you have comments, we are more than happy to receive them from you in writing by September 7th. So you will still be heard even though you're not able to talk today. We'll move then to John Miller, who is with the Mid-Atlantic Business Group on Health. Mr. Miller, welcome.
Thank you, Commissioner Bergan. Pleasure to be here. My comments are not so much directed at the specific content of the regulations, but rather I'd like to support the regulations in general. The Mid-Atlantic Business Group on Health is a coalition of large employers. We appreciate that the regulations are specific as to what employers and TPAs should provide to a regulator. Providing specific templates on reimbursement comparisons and denial rates is important because employers want to know what specific information is needed so they can be compliant. From what I've heard, both self-insured employers and their TPAs are asking for more specific guidance and examples of best practices, for example. In fact, it's our contention, our belief that the MIA templates could be used by other regulators. So we appreciate your leadership in this respect as well. And that pretty much sums up my comments. Thanks for the opportunity to speak on behalf of the Mid-Atlantic Business Group on Health. We appreciate it.
Thank you, Mr. Miller. Thank you for those comments. I also noticed that Dan Martin is here with us and has been moved over to as a participant. Mr. Martin, did you want to speak today?
Yeah, Commissioner Bergan, thank you so much. Again, I wasn't going to say make any comments, but after listening to the back and forth today, talking with a few folks over the weekend, I just wanted to make a few brief comments. Don't disagree with anything that our partners have been saying on this call, but I really wanted to, and there may be a need for some more tweaking of the regulations and the templates, but I really wanted to just highlight the positive, and thank you very much, Commissioner Bergan and the team at MIA for what you've all done here. First, just thank you for your opening comments, clarifying that Any NQTL can be audited and that network adequacy will be thoroughly assessed as part of the review of the NQTLs that you will be looking at. And so I've really just had two main points. Again, you and your team have done some really positive things here. You've provided very clear, detailed steps and instructions on how to analyze the NQTLs, which is important. And even more important, have provided templates, on reimbursement, on denial rates, out of network, et cetera, that specify the exact quantitative methodology that carriers should be using for a comparative analysis, which is essential to knowing whether parity is happening or not. And so, again, I just wanted to thank you for the steps that you've taken, appreciate the steps that you've taken, and we'll follow up with some more official written comments, but I just wanted to kind of share that with you here. So thank you very much.
Thanks, Dan. I appreciate that. I think as you and John both indicated, there's a tremendous amount of work that went into the templates and building the templates and trying to create something consistent and something that we hope other states will be able to rely on as well. We did not expect that we would publish them and everybody would say, wow, they're completely perfect and thorough. That's why we've invited commentary, and that's why we're having this hearing. So many of the comments today, as we get into the granular details, are appreciated and well taken and will be thoroughly considered. I don't know that we'll wind up in a place where everybody's happy, but that's rarely going to happen in any event. But I do thank you and John and Ellen and really all the partners for their support and providing us with their points of view, even if we don't always agree, particularly on some of the legal elements. I am very mindful and respectful of your passion and the work that you've done, and I appreciate all your comments. So is there anybody else who's indicated that they would like to be heard from? Craig, I didn't see anybody else.
Yes, I'm not seeing anyone.
Is there anyone from the MIA team, David or Erica in particular, that would like to provide any wrap-up comments?
This is Erica. No, Commissioner, thank you.
I don't really have anything to add at this time either, but thank you.
So I know that there were several members of the General Assembly that had signed in as attendees. I'm not going to highlight anyone in particular, but I just want to make sure that if there is anyone from the legislature who wanted to be heard today, we're very happy to take your comments. Just give a second for anybody who wants to weigh in. But what I will say in the meantime, waiting just to see if anybody takes us up on that invitation, is that we do have, we're open until September 7th for additional comments. We do hope to get detailed, granular comments along the lines of what was discussed today. We will go through them in great detail. The regulations, if you separate out the actual regulations from the templates, that would be appreciated. We will be moving the regulations forward pretty rapidly. The templates are provided for within the regulations, but they are not literally a part of the regulation. So we'll move the regulations forward quickly so that we're able to meet the December 31st deadline with the regulation process. The templates, because they're not attached, if you will, to or part of the regulation, we will continue to work with iteratively over a longer period of time. So I just wanted to kind of lay out that process for folks. Okay, and I don't see anybody else who's asked to speak. Craig, am I missing anything?
No, I don't think so.
Okay, well, in that event, I truly want to appreciate, I truly want to thank and express my appreciation for everyone who participated today and gave us their thoughts and their wisdom. I deeply understand the passion that people have with respect to this issue. It is a critical issue. We are going to move forward in doing the very best that we can do in assuring compliance with mental health parity. And with that, I think this will bring this third hearing to a close. And I look forward to probably our next and last one, which will happen after we reset the templates. We will probably have one more hearing on that next set of templates. All right. Well, thanks everybody, and have a safe day and a great week.